Welcome to the PI Show viewers. This is a show where we talk about everything relating to personal injury law and how it relates to you, the viewer. My name is Nunzio Tartaglia and I'm a partner at an insurance law firm in Victoria. With me I have Don Maffia, a TAC partner at a law firm in Melbourne.
Good evening, Nunzio. Good evening, viewers.
And Sarah Snowden, a senior associate at a Melbourne law firm specialising in superannuation.
Good evening, Nunz. Good evening, viewers.
Tonight we have a special episode where we will be talking about superannuation, hence why we have Sarah on the show to help out, and two interesting topics that we'll talk about later.
But Nunzio, let's talk about what's in the news first.
Okay, well the first article, Don, is that of the cyclist chasing compensation. What's all that about?
Cyclist enters into a competition or a road bike race, if you like, and hits a raised pavement area or on the concrete, falls over, injures his neck, collarbone, sustained injuries, and now seeking compensation from not only the the race organisers, but also the council.
And Sarah, why is he suing these two bodies?
He's suing them for damages for medical expenses and reduced work capacity going forward for the injuries sustained, on the basis that it was the first time that he'd actually ridden that track, so he wasn't familiar with the road, and they'd failed to warn him or put up adequate signage as to the condition of the road.
It's a difficult one because, look, generally to sue a council when it comes to sort of imperfections in the road, they have a lot of protection, Don, pursuant to statute and also common law. But when you got an organised race where they know the path that they're going down and it's controlled, I think this changes that a little bit, don't you think?
Well, it does, because look, as organising a race, and as we know, Nunzio, with that the poor lady who was running the race up in the Northern Territory went through the fires and got burned. They have a duty, they have to go out and check the course to make sure it's safe. But they've also added in the council, and the council looks like we're well aware about this section of the road area or the concrete that was raised, and they haven't done anything with the complaints or put signs up or done anything. That's why the council's added in as well. But it just goes to show, look, if you just hold a race, you need to take these precautions. Yeah. Look,
I think that it seems like a viable case on the facts of it, and if you can get over the relevant threshold, you might get some compensation. Sure. The next one is a sad case, but look, interesting at that, it's a pub fine for a death of a man after he drank too much, unfortunately, Sarah. What happened there? Unfortunately,
this patient has been served, it seems, excessive amounts of alcohol. He was then driven home by bar staff in an unconscious state and left at home. He subsequently has passed away as a result of the level of intoxication, and it certainly raises questions with respect to the responsible service of alcohol, and at what stage pubs and hotels need to start looking at the potential consequences of.
Well, they've been fined $60,000, but it doesn't seem, well, from the article, that there's been a court case or civil case on foot. But do you think there could be one here, Don?
Oh, look, I think it could. I mean, he was so drunk. I mean, this guy's so drunk that he actually died from the alcohol. Well, it's alcohol poisoning in the end. Look, you've got to look at all the circumstances, how he conducted himself. It appears that the hotel people actually knew he was so drunk that they actually put him in the back of the car to take him home. So look, Nunzio, like everything, possibly.
Where does it stop though, Don? They got him home. He was obviously alive at the time. Where does their duty stop? Should they take him to hospital? Like, what should have they done?
Well, they probably should have stopped serving him alcohol if they knew he was so intoxicated. He would have been so intoxicated, it would have been so obvious, well, I'm assuming now, but it would have been obvious he was so intoxicated, and just keep feeding him the alcohol or serving him the alcohol has put his life at risk.
So do you think there could be a viable sort of common law case there?
Look, obviously, like everything else, need a lot more information. But look, I think the responsibility, as Sarah said, there's got to be some responsibility on the hotel owners. They cannot just keep giving alcohol to people if they know they're so intoxicated.
I think they should definitely be monitoring the level they're giving more closely, so that doesn't actually get to this point where you're taking someone that's in an unconscious state back to their home in a car. So.
Correct.
Well, the next case has got some major press, and it's actually a really sad case, is the mother who's unfortunately was given commercial oven cleaner to eradicate hiccups when it should have been vinegar. What's the story about, Sarah?
Oh, this is really sad, Nunzio. This is a 40-year-old mother of one who was at a restaurant and had a case of the hiccups, something really common. The restaurant owner has given her oven cleaner instead of vinegar as a method of quelling the hiccups, and unfortunately the result of that has been quite significant on her livelihood, resulting in 37 operations.
And she has to eat through a tube for the rest of her life, is that right, Don?
That's correct, and it was just a spoonful of oven cleaner. It was one spoonful and just destroyed her internals.
And
So
she's incurred, I think, $150,000 worth of medical expenses. She is a lawyer and obviously is now cannot practice or is ceased practicing.
Yeah.
How big's this case?
Look, it'll be huge with the amount of treatment that she needs ongoing. I mean, being fed through a tube, the care, she's off work, she hasn't returned to work. I mean, this is just from one spoonful, and she ended up in 3 days in a coma. This is how bad. They didn't think she was going to survive. So I think it'll be very significant. And then you look at also what we call here the G&K, Griffiths and Kirkmeyer. Nunzio, what's that about?
Well, basically, that's the assistance she requires now that she never had to worry about. So the things that people are helping her and the things that she needs at home, she's going to get compensated for that. And look, that's going to be massive.
Well, at the moment, she's already incurring over $1,000 a week just in liquid fluids, liquid food, and also medications. So, and that's going to be ongoing.
Look, it's very rare where you hear an insurer say that they're looking for a quick settlement. And from what we understand through the articles, that Lumley Insurers wants to try and resolve this. And I reckon they're looking in the millions.
Oh, I would think so.
To be frank with you, so it's because there's liability has to be admitted. So,
and believe it or not, the restaurant manager that gave her the spoonful of oven cleaner never apologised. So. Okay,
the next case is that of the grapes in the supermarket. What's this one about, Sarah?
So a 30-year-old lady has slipped on a grape at a supermarket in Woolworths, and she's claiming damages for an aggravation of a PTSD condition that she previously had, and also physical injuries as a result of the fall. There's obviously some contention between herself and Woolworths at the moment as to whether or not the incident actually occurred. So it's going to be a very interesting case, this one.
Don, what's the issue about liability? Why is Woolworths taking a stronger position on this one?
Woolworths are saying, Nunzio, that just didn't happen, that she did not slip on a grape because she took a couple of days to complain to them about this grape. So their defence is, didn't occur.
I suppose the lesson for these cases is that if you do have a slip or a fall or anywhere, you should report it on the day, because contemporaneous evidence is always the most important and of greater use in these matters. Is that
absolutely,
true,
definitely. The sooner there's some record of the incident and thereafter treatment undertaken, the easier it is to actually prove a claim later on if you've got significant injuries.
Well, why don't we take it one step further? Take a photo of whatever was on the floor. We all got phones, we all got this camera access to it. Just take a photo.
Look, I think at the time you think it's innocuous and look, I should be okay. I'll take some Panadol and get better, but it doesn't always work like that. But anyway, we'll see how that one goes, because I think it's due for trial in November. It's time for a break, but when we return, we'll be speaking about superannuation and two really important cases. Welcome back, viewers. Tonight's episode is about superannuation, two important cases that came out of New South Wales jurisdiction recently. But first of all, look, we've got Sarah. So Sarah, tell the viewers, superannuation, TPD, what exactly is it? Because it's been a while since we've had this refresher. So.
Yeah, absolutely. So superannuation insurance is an insurance benefit that a lot of people will have through their superannuation funds. Some people do take out insurance separate to their super funds through a retail claim, but generally that entitles a person that becomes injured or suffers from an illness to claim a lump sum benefit if they're unable to return to work because of that injury or illness. So it's a significant amount of money generally, and it does help people when they're off work.
Don, does it vary, these amounts?
Oh, look, definitely varies. We've seen plenty of different amounts in practice. And the other thing too, it's just not injury, is it? It could be also an illness. So if you get sick, unfortunately, have something that prevents you from working, not through any injury or anything, just an illness can also entitle you to this total and permanent disablement. And that's all. Look, I think a lot of viewers or workers, they don't realise sometimes how important your superannuation cover is, because it gives you so many extra entitlements, and we'll speak about that later in the cases that we've got, because some big monies can be had out of it. Yeah, absolutely. And these cases demonstrate the money that can be had when people are making a claim. So what's generally the test though? In the TPD matter, total permanent disablement,
what generally is the test that a plaintiff or worker needs to suffice?
So generally the tests vary from fund to fund and insurer to insurer, but generally it requires that the insured member be off work for 6 consecutive months and thereafter be unlikely to return to work for which they're suited by their education, training and experience. So the fund and insurer will look at the work they're doing at the time, their previous education and what transferable skills they have to return to some other form of work in the future.
So when it's 6 months after date of injury, does all these matters have to be issued 6 months after? Is it one of those things you have to wait till they're stabilised?
Yeah, absolutely. So, particularly given the significance of some of the injuries that we see, they take a long time to be able to be assessed because they're not stable. You know, someone with a back injury may have to have surgery. They've then got 12 to 18 months of recovery if the surgery needs to be redone. So it can be years after the actual injury that a claim is initially lodged.
Don, you have obviously a big TAC practice, and obviously you have catastrophic injuries. You must have so many clients who have access to superannuation entitlements.
Well, correct. I mean, look, generally, if they're a worker, if they're employed, then there'll be some, or most likely will be some TPD insurance attached to superannuation. But even if not, they may have their own private insurance and things like that. So yeah, definitely, and that's a question we always ask. The first interview we say, do you have a superannuation or TPD entitlements?
And sometimes they can have more than one.
Oh, well, they're correct. I mean, I remember funds. I mean, I've got a few funds lying around because I've changed over the years. But yeah, look, you never know. It's just you get an authority, you put into sometimes even the tax office to find out if there's any unclaimed supers and things like that. And you get all these 3 or 4 different type of superannuation or TPD entitlements, which can add up to a sizable sum.
Well, you raised an interesting point there about generally they're working when they've got these funds. What happens, Sarah, in those situations where an injured person's not working, but they've got funds that say that they've got TPD at the time of their injury? Do you have any entitlements?
Yeah, the policies generally do pick up on that. And again, this varies from policy to policy and fund to fund. But generally, if you've been working in the 6 to 12 months before the date of injury, if you're not working at the time, some policies will pick up and you can still be entitled to the full TPD amount. If you haven't been working for the 12 months prior, then usually it reverts to what's called an ADL's test, which is an activities of daily living. And that's things like eating, feeding, dressing, housework. And generally, if your injury or illness is so significant that you can't undertake those activities of daily living, then you can still be entitled to
So how do you prove something like that?
Again, you need as you would for any TPD claim, you need medical support. So you would need a report from the doctor or from a specialist that says that they cannot undertake these certain activities because of the condition.
Okay, and just before we get onto the cases, though, Sarah, what's the process of making a claim on a TPD? What's the first step, and ultimately, where can it potentially get to?
Yeah, look, because of the variation in the policies and the significant complexity of the issue in terms of the things that the funds and the insurers look at, my first suggestion would always be to seek legal advice on your entitlements. You want to make sure that your injuries are stabilised and you've accessed all appropriate treatment before looking at a claim. The funds and insurers are always looking at transferable skills that people have, and as I said, because the policies vary so significantly, seeking legal advice at that early stage before going any further is absolutely crucial.
Well, it appears like most of the litigation surrounds around whether the person would ever be likely to return to some regular work. Yeah. And then using their transferable skills. I mean, we can all say we've got transferable skills. I mean, at one stage, everyone could be the lift operator at the My Department store. Everyone can do that. But yeah, it's really whether or not such work is reasonably available to the person.
And that's what we find, obviously at the firm we have, hundreds and hundreds of clients come with TPD claims, and they usually start them off their own, Don, and we see so many errors because they don't realise the importance of that second limb of the test, and you need to get the appropriate evidence to get that. And that's what concerns me when, plaintiffs or injured workers do it on their own, is it? Would you say?
Yeah, absolutely. The amount of claims that we have come through after the claimant or the injured worker has tried to lodge the claim themselves, and the process is a very long and strenuous one, and the funds do drag them out as long as they can.
Yeah. I think in one of the cases we'll go through soon, He went 3 or 4, 5 times back to the fund trying to get it approved, and approved years and years and years later, and ended up litigating. So
that's right. Look, we may as well, it's a good time to go into a case. The first one is Sharp v Maritime Super, which is a recent 2012 and 13 case. There was 2 proceedings within this sort of one matter. So do you want to just give the facts to the viewers?
Yeah, absolutely. So Mr Sharp was employed as a stevedore working at the docks, and unfortunately he was terminated because of the circumstances in his work. So he wasn't performing well. He was deemed to be sort of unsafe to be working with, and so his employment was terminated. He was subsequently diagnosed with schizophrenia and a psychiatric condition. And he then lodged a claim on his fund for total and permanent disability benefits. Now, the fund actually rejected the claim on the basis that he did not cease work because of an injury. The issue in this case, and the main issue, was whether or not the illness that he had, so the psychiatric illness and the schizophrenia, was the reason for him ceasing work or being terminated from work.
So Don, exactly that issue of termination was prevalent in this case, and what ultimately was decided in that regard?
It was decided, I think the employer told the fund or the insurer that they didn't terminate on the basis of any underlying medical condition. But the insurer, the fund, knew about this connection when he lodged his claim for the TPD, because there was medical evidence connecting it all. So it's all that. So ultimately the court said, well, there's a duty on the trust or the funds to investigate this possible link, and they never did. They never did until 2012 or thereabouts, when they started getting their own medical evidence, and that actually tied it all in. So they found for the worker or the plaintiff in this case, and the amount was paid out.
How much was the TPD in this amount?
$453,000.
So we're talking about some sizable entitlements here, and look, after we come back, we'll speak about the second sort of proceeding that stemmed from this this TPD entitlement, and it shows that the size of these matters. But stay tuned anyway. Welcome back, viewers. Before the break, we were speaking of the case of Sharp v Maritime, and the plaintiff was successful in a TPD amount of $453,000. So don't explain to the viewers the process he went through, though, because he had a couple of rejections and had to issue proceedings.
He did. So he initially lodged the claim back shortly after the injury in 2006. Following that, there was a rejection by the fund. He then lodged some further material on the insurer and trustee on the trustee for assessment. They reviewed that again and then subsequently rejected the claim again. And then he again lodged some further material on the fund, so some further medical material, and again the trustee determined that he wasn't TPD. After that, third rejection, he then issued proceedings. How
many times can you go to a insurer and trustee and say, please reconsider my claim?
Oh, look, there's some interesting case law on that point itself. It could be another episode just on that. But generally, if there's more information provided, then the fund and the trustee is under an obligation to review the claim, because they have to have all the evidence necessary to allow them to make a proper decision. So if that evidence can be provided, then they certainly should be taking it into consideration.
So Don, this claim was issued or made a claim, the plaintiff made a claim in 2007, 2 or 3 rejections, and he issued proceedings in 2011, and I think 2012 is then when obviously the decision came down.
Correct.
So there's about 4 or 5 years there where then the plaintiff said, well, I want my interest. Is he entitled to do so? Well,
there was separate proceedings by the plaintiff in this matter, and the court said yes. The court said, all right, well, if the fund did its job properly, and the job was to investigate this connection, because at the time they were saying, no, you were terminated not because of a medical ground, but because of poor performance. But then it all tied in later on. So if the trust fund did its job properly, it would have been about, a year or so after it was first claim lodged, so it took interest from then to the date of trial.
How big was interest, sir?
Oh, in this case, it was absolutely massive. It was just short of $250,000,
Wow.
so $247,000 in interest on top of the $453,000 TPD awarded by the court. So, look, interest in these cases can be absolutely huge, and I think it sent a really strong message to trustees in these matters that they can't just prolong these claims forever and leave the insured members hanging on. There's going to be consequences if they're not being proactive and actively pursuing the claims for their own members.
Well, let's not forget, these are benefits. These are insured benefits for the benefit of the person.
That's right.
So it must be taken in that regard. I mean, it's held for the benefit of you and I, everyone in there. So the court said that there is a high duty on these superannuation trustees to make their inquiries, not just to accept something. Like in this case, it was just an employer saying he was sacked not because of a medical condition.
Well, viewers, it's case in point at how important it is to have insurance cover and how important it is to seek legal advice when you may potentially have a claim, because we're talking almost $750,000 here, which can set up your life. So please get legal advice when appropriate. Next case is that of Falan v United Super. Sarah, what are the facts of this matter?
Yes, so Mr Falan was working in the building construction industry. Unfortunately, he was involved in a motor vehicle accident and sustained an injury to his elbow. This is a perfect example of a case where he didn't go to hospital immediately, didn't have surgery immediately. It took a little while for his injuries to stabilise. He did eventually have surgery on the elbow, but never returned to work following the accident.
So, Don, what was the big prevalent issue in this case? Because obviously it got to a point where proceedings were issued in the New South Wales Supreme Court. What ultimately did the court criticise the trustee for not doing?
Again, Nunzio, the issue in this case is whether or not the trust fund the superannuation fund had made those reasonable inquiries as to whether or not the plaintiff in this case was able to return to work or had any opportunity to obtain regular work.
And what inquiries should have they made?
Well, in this case, what happened was that initially the plaintiff went through a rehab process, a Commonwealth Rehabilitation Service, and very early on the piece, I think at the time he was having surgery or about to have surgery, they investigated what possible things he could have done, such as being a crane controller, crane operator, traffic controller. I mean, this plaintiff was a labourer. That's all he did, heavy physical work. So they're trying to identify other issues. But ultimately, the rehab service closed off those investigations, saying, well, he's not stable, he's not fit. Although these are identified, we still can't explore whether or not he can do it. And the fund in this case took that as gospel and said, well, he's got transferable skills, so therefore he will be able to get back into regular work.
Yeah. So they obviously should have explored it more, but the part about the case that I think that is great and favourable to plaintiff Sarah is the court's approach about theoretical work as opposed to the common sense approach. Can you get back to work and what type of work? What did the court decide or state in this case?
Yeah, absolutely. So this case has absolutely maintained some previous case law in this area, which requires that the fund and the insurer actually look at the reasonable prospects of an injured worker or returning to work and actually obtaining that employment in the real world. So it's all well and good to go off for a vocational assessment and be told you could do a crane operation job or this, that and the other. But those vocational assessments aren't done by medical professionals. They're done by people that have got that rehabilitation and look at the transferable skills. So those skills or those opportunity or positions that they come up with may not be available. They may not be readily available. Crane operations require significant training, retraining, and they may be only 2 or 3 available in the whole state. So that's what they've got to look at in terms of it being reasonably available in the real world, not just some theoretical idea or position that they've come up with.
And the fund in this case, just reading the judgment, which you agree, it was just as simple as the fund going in and making its own inquiries rather than relying on what was an incomplete assessment at the time. And through years and years and years and years of litigation in the end.
Yeah, and the treating surgeon for the plaintiff almost set it up for the trustee in the fund by saying, well, he probably needs to be assessed by an occupational physician, and they still didn't attend to that. And that's all what probably would have taken for a proper decision to be made.
Absolutely, and that was pointed out in the vocational assessment as well, that the positions identified needed to be assessed by a doctor. They went back to the surgeon. The surgeon said, I'm not in a position to say that he could do this unless it's in the restrictions that I've set, I've said he could do. You need to go and get a position or an opinion from an occupational physician, and they didn't do it. They just took it on the words of the vocational assessor.
And ultimately, like the last case, because of the delays and the fact that they should have, I suppose, been a bit more proactive, the fund.
Yeah, absolutely.
One, the plaintiff was successful for his TPD amount, I think it was $100,000, and interest at it from an earlier point because they should have taken those tasks on earlier.
That was a really important point too, was that they took another year, or they wanted another year after the receipt of that last report from the surgeon. That's when they wanted interest to accrue from it, and the court wouldn't have a bar it. They said no, 3 months maximum is how long you needed to be able to review and obtain further information if necessary to make a decision.
Look, it's a great case for plaintiffs and workers, and you know, I'm sure that it'll assist going forward. But look, that's all we have time for tonight, viewers. It's been a really interesting show, and I'm sure we'll speak about TPD and get Sarah back on shortly anyway. But Don, any advice or recommendations for the viewers?
Of course, if you're injured, you can contact us, or you're suffering from an illness, not even injury, illness, and you have some entitlements, maybe through super or other entitlements, give us a ring or contact us on our website, weekcarbone.com.au or 1300 injured.
Sarah, thanks for coming on, and I appreciate your input.
Thank you very much.
That's all we have time for tonight, viewers, but we'll be back next week. Stay tuned and stay safe.